Well, good afternoon. We're about to start, so if you could make sure you're ready and sitting comfortably, that would be great. So, hello everybody, a warm welcome. Thank you for joining today. You may be familiar with my voice already, but if you're not, I'm just going to start by making a few introductions as always. So, my name is Karen, and I am the HR Knowledge Manager at HR Solutions, and I'm presenting today. And I am joined by my colleague, Atim. She's here in the background, so if you had any questions or any technical problems, if you use your control panel to send her a message, she will try and get back to you. Otherwise, we'll collate any questions you have, and I will certainly look to try and come back to you shortly afterwards. As always, we will be recording this session, so you will be able to watch it back again at any point if you should wish to do so, or if you want to share it with anybody, then that would be great. And if you wanted the slide deck, let me know. I'm more than happy to send that across as well. So, we are starting a series today. We are going to be looking at some key HR topics and thinking about how we can minimise risk in those areas. So this is the first in that series, and we're looking at absence management. In this webinar, we of course have only got an hour, so we're going to be looking at the following few things today. Looking at managing an AWOL employee, when it might be safe to assume resignation. Looking at how you can reduce persistent short-term absence, because that's notoriously an issue for many employers. Some legal tips on long-term absence management. And lastly, just summarising when you can dismiss due to absence if in doubt. So hopefully by the end you'll feel a little bit better and a little bit more aware about some of the legalities that are at play here. We will have considered differing approaches that you can take. So hopefully there's things that you can take away from this session and implement that you feel comfortable with. And hopefully you'll understand the importance of distinguishing from absence which may be a conduct issue and which sort of absence might be a capability issue. Very distinct and very important that we get that right. So first things first, managing an AWOL employee. Anyone can be AWOL. However, only individuals whose employment status is an employee can be disciplined for being AWOL. Okay, so one of the first questions that is often missed, but is important to double check before you start taking action against somebody, is that they are definitely on a contract of employment. They're not a worker, they're not self-employed, they're not a volunteer, and so on. Okay, so going forwards, we will be looking at AWOL employees. This term, going back to basics, is something that's used to describe somebody who is absent without leave, okay? And typically these things will characterize somebody being absent without leave. So they're literally absent from work. They don't have authorization to be absent. They're not in contact with you, and there is no apparent justifiable reason for why they are not in work. So I'm going to give you a couple of scenarios. The first is an employee has been on sickness absence. Okay, they stop sending in sick notes to authorize that absence. They are not returning your calls, they're not responding to your letters requesting for a subsequent sick note. Okay, now this employee is technically AWOL, okay? Their sick note has expired, they've not provided you with justification for their absence. However, you may of course hope that your line managers might recognise that this is likely to become justified in the near future. Okay, so there's going to be a hope there that if you were to merely prompt this individual, or you could get hold of them, that is, that they might be able to send a subsequent sick note. But of course, if you are not successful and all of your calls are getting ignored, you've left a reasonable amount of time for a response, then you would look to continue down the AWOL process as far as may be appropriate. My next example, so you've got a new starter. They've turned up for the first day, but they've not turned up for the second day. Someone has heard on the grapevine that they've started working somewhere else. You're trying to ring them, but they are not contacting you. They're not returning your calls and not returning your emails. Okay, so in this situation, it's highly likely to be quite straightforward, and you're probably slightly less concerned about ringing an emergency contact, but I would still encourage you to do so because you just do not know what might have happened that morning. Okay, but if this is the case, then you are actually dealing with an AWOL employee. All right, they've only been with you for a very short period of time, but there may still be risks that you need to contend with, and a full process can iron out those risks. So just some comments on the way in which you should approach this situation. Okay, it is very common on our advice line for employees to ring us with an assumption that the employee has acted in a way that is misconduct. Okay, and we understand that. You know, it's very frustrating. It's generally considered to be, you know, the height of being miscourteous. It can even be deemed gross misconduct, and is often, in fact, the way in which we treat it. But you cannot jump to that conclusion. Okay, there may be a justifiable reason for the absence, such as, unfortunately, you know, something like an accident on the way to work. It happens, and it happens more than you might think. So we must always make sure that we are trying to make contact with that person in the first instance, you know, in several ways, just to check that nothing more serious is going on that might make you regret going down the route of misconduct. Okay. And in doing so, you know, remember that employers do have a duty of care and must make reasonable attempts to make contact. Okay, by making these reasonable attempts, you are demonstrating that you understand that duty of care, and ultimately you want to exhaust this, you know, before going down a conduct route. So it does mean that reasonable attempts should be made to contact the employee, okay? And please do keep records demonstrating this, okay? Now, if your attempts are successful, you may learn that the employee has a good reason for absence, okay? In this case, or at least in some cases, if there is a good reason for absence, you might determine that it's not appropriate to take action over the absence itself, okay? But sometimes it might still be appropriate to take a dim view on the fact that they might have failed to report their absence to you in a reasonable amount of time. Okay. Alternatively, there may not be a good explanation whatsoever. So it might be entirely appropriate, you know, for you to tell that employee that they are expected in work immediately, and that if they don't turn up, you will be taking disciplinary action against them. Okay. Now, an area where clients can get this wrong is they might manage to get hold of their employee, and their employee tells them, I don't know, they've gone on holiday, they're in Spain, you know, and employers will say, right, okay, well, we will need to discuss this when you get back, and hang up, okay, and then they call us. It's important that you tell the employee on the phone that that is not acceptable and that you expect them to be in work, okay? Even if it seems absurd, you know that they're not going to be able to get back, you know, they're not going to be able to catch a flight if they have gone that far, you know. But still, you need to make clear that your expectation is that that employee should be doing what they can to get themselves into work to meet that contract that they've agreed to. Okay, whatever that entails, you know, they've put themselves in that circumstance and they need to get themselves out of it. So, all right, realistically, you won't be expecting them to turn up, but you must tell them that that is what you expect of them, and that whilst they remain absent without leave, you will be regarding that as misconduct for the purpose of taking disciplinary action. Okay. Now, if you do make attempts and you really aren't successful, then that is when you need to start looking at following what's generally become accepted as the process for dealing with an AWOL employee. And when I say that, I'm really talking about case law which has established this practice. Okay, so here is a summary of the stages that you might take, and I've tried to encompass different eventualities here. So this is the good practice route, and is certainly the route that you must be taking in respect of all long-serving employees. Okay, I have put a caveat in for where you might want to assume resignation. So let's run through these quickly. First off, you must attempt to make contact on the first day of absence, okay, and preferably soon after they were expected to start work. Again, just in case something awful has happened to them. I would then strongly advise that you look to attempt contact on the second day of absence, okay? Some people may think that's a little bit lenient, but again, you don't know what could have possibly happened to that individual on the first day. The second day of absence is usually the following day, so it gives them, 24 hours to get in touch with you. So certainly to follow up on the second day is good advice. Following that second call, if several hours have passed and you've still not heard anything, it might then become appropriate to move to stage 3, in which you look at issuing a letter, which just at this point raises your concerns, okay, and instructs the individual to make contact with you urgently, okay. So if for some reason, they aren't able to get to a phone, phone lines have been cut off, what have you, this is, another method of communication that you have used, and letters are accepted as being, quite the beginning of a formal approach, really, as opposed to text or Facebook message or what have you. So let's stick with the good old-fashioned letters and get one through the post. And it is just saying, we're concerned about you, we're starting to consider that you might be AWOL, you must get in touch ASAP and before date, okay? And then stage 4, if that date passes and they have not contacted you, we would look to invite to a disciplinary hearing, okay? And it might be at this point that some employers would look instead to assume resignation, which we are going to look at in the second part of this webinar today. Now, if the employee does not attend that disciplinary hearing, then you are strongly advised, and I can't emphasize that enough, to invite them to a second disciplinary hearing, okay? So this is your second attempt to get them in. And at this point, you would forewarn them that if they fail to attend a second hearing, then you may make a decision in their absence, okay? And that is very important that they've had this opportunity to attend once and they're forewarned that you will go ahead without them on a second occasion, okay? It lends itself to being passable in tribunals, a fair approach, a fair process. And then lastly, of course, if they do not attend that second hearing, no attempts to contact you have been made, then you would look to dismiss. So I promised we would look at what rights an get my teeth in. We would look at what rights an AWOL employee has, okay? The rights that they have might affect your decision, might affect your approach, depending on the circumstances, okay? It really is a case-by-case basis, but generally, the process I discussed before is a one-size-fits-all. Now, when we talk about rights, we are usually talking about statutory rights, okay, so the legal rights that are afforded to an individual. But of course, many employees can use the word rights in regards of a number of different things. Now, not to scare you too much, but there are hundreds of various employment rights that could be applicable to an employee in any given situation. But I'm just going to focus on some of the key ones that you might do well to keep in mind in this circumstance. So I'm going to put them up on screen, and I'm afraid that we're not going to have time to go through these all now, but for example, one that you might not necessarily expect to see is sort of midway down the page here. So we've got the right to a written statement. Okay, so this might impact your approach a little bit. Now, this is referring to a contract of employment. If you have not issued a contract of employment to an employee within 2 months of their start date, okay, and they make a successful claim in tribunal about something else, then they can attach a claim for the fact that you have failed to provide them with a written statement of main terms of employment. Okay, so sometimes we might advise along the way in a process, if a client reveals to us that they have not issued a contract, then before dismissing an employee, especially if we think, you know, that there's any reason they might be able to come back and try and make a claim against us, we would advise to issue a contract, you know, perhaps enclosed with one of the letters, you know, asking them to let us know where they are. Which might seem odd, unexpected, but it's a surefire way to remove that ability for an employee to make a claim of that nature, especially if you think you are heading towards a dismissal situation. So there are a number here. We're running seminars soon, and the first one is going to be on absence, and we are going to look to go through these in a lot more detail there. So if anyone would like to join, then please do get in touch. So it'd be great to have more people along. So, as promised, let's look at how we can minimise risks for AWOL employees. This is a bit of a summary, but also a bit of a tick list that you can take away, if nothing else. So, consider adapting your absence management policy to include a very clear procedure. Okay, the clearer you are about the process you intend to take against an employee, the more difficult it is for them to argue against that process being fair, transparent, you know, or unexpected. Train any other managers that you might be responsible for to have a basic understanding of the legalities that I've discussed here, and also of good practices. Okay. The term AWOL is often chucked around, and we often think we know what we mean by it, and so assume that we know how to manage the situation. But actually, we're so often steering people back to the straight and narrow. So it's well worth investing in just general awareness training for your managers. And then going forwards, it is well worth ensuring that your managers have understood the training and that they are all following it consistently. Okay, so if you do have various line managers in your organisation, if any of them are treating the employees that report to them differently, it can actually undermine a case. Okay, if one employee is able to say, but Joe Bloggs was treated in this way and our situations were the same, then that potentially is grounds for them to appeal on, and maybe grounds even for them to say that your, you know, process was unfair and that ultimately the dismissal was unfair as well. Okay. Even if the reason was fair, you know, tribunals will distinguish between the procedure and the reasons. Always begin by making reasonable attempts to make contact, okay, if only to discharge your duty of care. Please issue a letter expressing concern for the individual first, and ask them to make contact with you by a certain date before you take things further, again to discharge that duty of care and just to check that there's nothing else going on that you might just feel awful about for not having established first, okay. And I stress the importance of inviting to 2 disciplinary hearings, absolute must for any long-serving employees, okay? And so when I say long-serving, I'm talking about employees who have continuously been employed with you for 2 years, okay? And that includes statutory notice, which is usually a week for most people. So let's move on and have a look at when it might be safe to assume resignation. Okay, so this is something that clients will sometimes do to avoid a full AWOL process, particularly if they don't feel they have the time or the resource to deal with the employee, and they've got reasonable assurances, you know, that they're not in trouble, you know, let's say, and they are just messing you about. So as I say, clients do this to avoid shouldering that responsibility of a dismissal as well. Okay, so not just avoiding the process, but they feel better, perhaps, you know, going down the route of saying this person has resigned, I haven't dismissed them, which is understandable. Okay. There is always at least some risk to assuming resignation, okay? And for that reason alone, we would never advise categorically that it is always safe to do so, okay? But what we will do is we will advise on the circumstances at hand and suggest what the level of risk is likely to be so that clients can decide whether or not this course of action is appropriate to them or appropriate to their business. Okay. So there's always some risk. Case law tells us that an employee's actions, or inaction in this case, must be absolutely clear and unambiguous that they have resigned. Okay. Now this is difficult when you are looking at inaction, because positive actions are always much clearer to decipher. But we've learned from tribunals that employers are getting this wrong, okay? They're not establishing that the action was clear and unambiguous. And so if an employer gets this wrong and is challenged by the employee, then it will render the ending of that contract as a dismissal, okay? Which of course the employer is then liable for. And if you have assumed resignation rather than following a due process, that dismissal is going to be unfair. Okay, so if the employee has the length of service to claim unfair dismissal, that is a risk. Even if they don't have the length of service to make that claim, I'm afraid, you know, there are many other ways in which employees can bring a claim in respect of something like this, which could leave you liable if you've got anything wrong along the way in concluding resignation. Okay, so for things such as notice pay or pay for the duration or the remainder of a fixed term contract, which can be quite significant. Wrongful dismissal. More seriously, if anyone can link your decision to assume they've resigned rather than follow a due process to some sort of discrimination or a recent assertion of a statutory right, then they may even be able to claim automatic unfair dismissal. Okay, and it doesn't matter how long somebody has been employed to be able to make that claim. Okay, so when I'm talking about that, and I'm going to give an example for a statutory right, because that tends to be a little bit less clear. Let's say that somebody has recently put in a request for flexible working. Okay, they qualify, they're eligible to make that claim under the Employment Rights Act. So applying for flexible working was the assertion of a statutory right. Okay, the employee doesn't turn up for work shortly afterwards, we assume resignation. Every other employee has had an AWOL process followed. This individual might say that they think we were trying to fast track getting rid of them because they had recently asserted a statutory right. Okay, and that is one of the biggest claims. Automatic unfair dismissal is one of the biggest claims that can be made in an employment tribunal. Okay, so I mean, we could go into a massive degree of detail on this. As I say, we're doing a seminar soon, but I would say if there is any doubt whatsoever over an employee's intentions, then it is advisable to follow a full AWOL process. Now, if you did want to go down this route, what you would probably do, and I've just grabbed a screenshot there from the earlier slide about the process, is you would just perhaps go through stages 1 to 4 here. If you do stages 1 to 3, then you are minimising dramatically the chance that the employee is going to be able to come back and say, but you didn't take into account X, Y, and Z. You didn't make reasonable attempts to try and establish if anything more contentious was going on here. Okay. Some employers are trigger happy. They just want to get that assumption of resignation letter issued. That's up to you. But as I said, we cannot say that that is without risk. So a bit of a checklist then, if you ever fancied this route. I would strongly advise that you still begin by making reasonable attempts to make contact, to try and establish whether or not something contentious has potentially happened. I would limit this course of action to employees who have a short amount of continuous service, who are unlikely to be able to claim the decision was discriminatory in any way, and who have not recently asserted a statutory right. Okay. And I would suggest when you make the initial letter encouraging the employee to make contact with you by a certain date, forgive me, actually, when you do issue the assumption letter of resignation, that you include a line in there to say that if we have been wrong in reaching this conclusion, that they should contact you as soon as possible, you know, and upon receipt of the letter, ideally. And in the background, realistically, we should be willing to go through a full process if they do contact you, okay? It may still be that it results in dismissal, but at least in this case, we are following due process, and it's unlikely that they will be able to make many of the other claims. So let's move on. We're going to look now then at persistent short-term absences. So these can be really frustrating for many clients because you feel like you don't know where you stand, you don't know if they're going to come in from one day to the next, you know, work is disrupted, service to clients is disruptive, all sorts of issues come along with it. Sometimes employees are quite pesky as well and never quite hit a trigger, which is frustrating too. So short-term persistent absences, ultimately, when starting out, okay, we always need to bear in mind the end game. Hopefully we'll never have to get there, but whenever we begin a formal process, we're ultimately thinking about, you know, will this process be fair, playing devil's advocate, if we ended up having to dismiss this person? Now, if you have to dismiss, and you want to dismiss fairly, in the legal sense of the word, then you have 5 potentially fair legal reasons for dismissal. And if you choose the wrong reason, then that dismissal is potentially unfair before you've started. Okay, so we need to have these 5 fair reasons in mind from the outset of any management process, because there is usually, or in fact always, I'm going to say there is always an accompanying appropriate route, and they're all distinct from each other. Okay. Now, when we're dealing with short-term absenteeism, we're potentially embarking down either a dismissal for conduct or a dismissal on the grounds of capability. Okay. A dismissal for conduct, we're looking at a disciplinary route. And a dismissal for capability, and usually with absenteeism, we're looking at medical capability. Okay. So as I said, you must choose one or the other. Now, in order to establish which route is most appropriate, you will have to have an initial conversation, okay, with your employee, because you have got to do the groundwork to establish what's going on in the background, okay? Burden of responsibility is on you, folks, I'm afraid. So there are various ways in which you can start to approach this, okay? I'm not going to talk about the full-blown process in this webinar. There's just simply not enough time. But what I am going to do is give you some tips on approaches that you can take from the outset. There are many different approaches. These are some of the key ones. Now, you can use all of these, or you can just use some of them. And your decision as to which you go with might be subject to the circumstances. Okay, some lend themselves more towards disciplinary route, some lend themselves more towards a capability route. So we're going to start by looking at returns to work. Okay, so a return to work meeting, you might have heard of this. Forgive me if I'm preaching to you something you already know. This is a one-on-one documented meeting. Okay, so it's technically an informal meeting, and it follows any unexpected absence. Okay, usually the following day or as soon as possible. During the course of the meeting, you will consider any previous return to work meetings that have been held. Okay, so you'll dig out past documentation that you've created, and you will tally absences over a specified period of time. Okay, so this is usually over a rolling year. Okay. Now, the benefits of these are that they do deter any non-essential absences. Okay, because quite frankly, if somebody knows that if they were to phone in sick, you know, or with any other reason, and they knew they were going to have a conversation with their line manager specifically about this when they get back, they are far less likely to make that call if it's avoidable. You know, if it's a headache for which they're prepared to take paracetamol, you know, if it's something they can make alternative arrangements for. It just stands to reason people want to avoid that uncomfortable head-on conversation, especially if there's certain disquiet among, you know, within themselves about whether or not that was absolutely essential to have that time off. And another benefit of them is it does track the development of frequent absences. Okay, quite often we get calls from employers and they say this person is just having time off all the time. You know, when? And like, well, a few times last month, just gone off now, several times over the year, really, you know, and they might not have kept track. And we get that because you've probably got far better things to do. But it does mean that when you start to notice it's an issue, we've not got a lot of evidence to work with. So you might almost have to start from scratch. Okay. Whereas if you've carried out return to work meetings, you're likely to have minimised absenteeism in the first place, and secondly, we do have evidence to move forwards with, which help us to determine whether we need to be going down a disciplinary type route or a medical capability type route. Okay. Hopefully, if there were reasons to suggest a medical capability type route were on the horizon, then they might make themselves apparent through patterns. Okay, so any absences which tend to be for the same reason, they start to point to a genuine medical capability situation. Okay, is there an underlying issue going on that we need to be aware of? It's not always medical, it's not always illness, it can be pregnancy. You know, it can be some other type of serious or protected issue that the employee has. But I'm generally going to be talking about health in this webinar. If you review return to work meetings, and they tend to always be something different, you know, this week it's DVT, and next week it's a headache, and the week after that, you know, it's some other sort of stomach bug or, you know, virus. If it's always something different, and your employees are quite inventive with the reasons, they often think that that's quite a good way of preventing you from being able to take action against them because it's different, but actually it's the precise opposite. Okay, if it's always something different, it quite often suggests there's not an underlying condition that you have to deal with, therefore it's unlikely there's anything long term we have to support you with, and therefore actually we have no choice but to treat your ongoing absences as a conduct issue. Okay, so another approach that you can take is the Bradford Factor. Okay, so you might have heard of this, you might even have implemented it already. But the Bradford Factor essentially is an equation which produces a score in respect of each employee based on their level of attendance. Okay, so this is designed to capture persistent short-term absenteeism specifically, okay? And in effect, what would happen is the equation would produce a higher score for people who have a higher frequency of absence rather than a long-term period of absence, okay? So some examples here. I've put that S equals the number of occasions of sickness within a given period, and D is the number of days absence. Okay, so if somebody had a single absence that lasted 12 days, so this person is particularly poorly, but it's a one-time thing. Okay, we've got one occasion times by itself multiplied by the number of days, which gives us 12. Whereas on the flip side, if you had somebody who had 12 separate instances of absence, each of them lasting a day, then you would do 12 occasions times 12 occasions and then multiply that by 12. So each of the days, and you would get a figure of 1,728. So you can see that that creates a massively different score. Okay, 12 versus 1,728. You know, this long term, this person with the longer term sickness issue is flying under the radar, whereas this person who is having 12 instances of absence over 12 days altogether is generating a hugely significant score. So this would highlight to you immediately and very clearly that you've got somebody with a persistent short-term absenteeism problem. Okay. Now, this technique can be great for that. It gives you an instant snapshot. You might set yourselves boundaries, you know, or what we refer to as triggers. So if somebody gets over 650, it will trigger a documented discussion. You know, if they get over 1,500, following a disciplinary procedure, it's likely to result in a written warning, and so on. Okay. This does require you to continually monitor absence because you would have to ensure that you're treating everybody fairly and consistently, and that once these triggers do occur, you are taking the action in a timely manner. But what this is not great at is two things. It's not very good at treating people who are part-time fairly. Okay, it actually favours part-time workers. For example, if a part-time worker did 3 days a week and were ill for a week, and a full-time worker was off for a week, then the full-time worker is going to have their score multiplied by 5 if they do 5 days a week, and the part-time person is going to have their score multiplied by 3 potentially if they did 3 days a week. So for two people who both took or were both only ill for a week, one would generate in a score significantly higher. So you would have to manually make an adjustment for part-timers in order to be consistent. What also it doesn't do is it doesn't take into account the actual reasons for absence. There is no human element to this. Okay. If ever we get calls saying Joe Blogs, you know, Sue Brown has triggered Bradford Factor of whatever it might be, we will always be asking first, can we remove any absences related to a disability, pregnancy, emergency time off for dependents, and so on and so forth. Okay, you must not take disciplinary action in respect of things such as that. My next approach is letters of concern and targets. Letters of concern are great, right? So these are letters which are issued outside of a formal disciplinary process, okay? So they're technically an informal letter, but they're nonetheless quite formally written, and I certainly wouldn't want to receive one. They will follow a discussion about concerns over a level of absence, you know, so if you haven't been able to track and monitor absence, but you know yourself, you know, that this has become an issue, you know, quite genuinely, you can sit down with this individual, you know, talk to them about what might be going on, any patterns that you've noticed, and whether or not they think there could be any reasons for that. And if there are no contentious or underlying issues, you might follow up that conversation with a letter such as this. Okay, and as part of it, you can advise a target that the employee should work towards. Now, these are great, okay, because if you were to launch down a disciplinary route, straight away, an employee could potentially argue, I've been absent several times over the years that I've worked here, and you've never taken disciplinary action against me. Now you suddenly are. That's inconsistent. That is not fair. My expectations and understandings have not been managed. I had no reason to know or to expect that being absent on that occasion would trigger this action being taken against me. Perhaps if I had known, I might have forced myself to come in. Ugh. Annoying, but happens, and is something we have to take seriously, unfortunately. So if you're in a situation like that where things have perhaps got away from you a little bit, these letters will reset an employee's expectations. It forewarns them, okay? In the past, you might not have had any action taken against you, but we're telling you now that going forwards, if you don't meet this target, you can expect a formal disciplinary route on the next occasion, okay? This is great because it puts ownership over what happens next back into the hands of the employee, okay? I've not met anyone who likes taking disciplinary action. I think we've all frankly got better things to do. It's upsetting for everybody, but particularly the employee. If we have to do it, we do it, but we prefer not to. So that employee essentially is told, I don't want to have to do this, but if you do X, we will have to. So avoid doing it, okay? And then if you do have to do it, this is not out of the blue. This is not news to them. On their own head, be it, okay? You would, of course, have to follow a process. And of course, again, if there were any contentious reasons, you would have to take that into account. But if there was no good explanation, then that is what we would look to do next. And then I wanted to look at reasonable adjustments. So this can also be a way of reducing persistent short-term absenteeism, okay, and is more likely to be the one that you lean towards if you have uncovered an underlying health concern. And again, I'm generally focusing on health issues, but under the Equality Act, employers are obligated to make reasonable adjustments in respect of anybody who has a protected characteristic and for whom would be at a detriment compared to an employee without that characteristic as a result of your provisions or criteria or practices, okay? So, for example, in respect of a disability, this might require some flexible working. Particularly if any symptoms were flaring on a temporary basis. A religion might require more frequent short breaks on particular days or particular times of the year. Somebody who is pregnant might require you to adjust a Bradford Factor score, as I've said previously, and so on, okay? These are all examples of potentially reasonable adjustments that you might make in respect of somebody who has a protected characteristic, who is struggling to meet whatever you expect of them, of your other employees because of the characteristic they have, okay? But nonetheless, and don't get me wrong, I do think it is still important to have a discussion with the individual when you are noticing these things, particularly if they are becoming disruptive, okay? Transparency is always valuable, okay? If you're harbouring concerns, that's going to manifest itself and push you to want to take more extreme action than may be appropriate given the employee's expectations of a situation. But equally, if you're transparent with them, it gives them the opportunity to see whether or not there is anything they can do themselves, you know, and opening that dialogue usually prevents you having to take any drastic action and also helps you to understand what adjustments might be appropriate and for how long. So having a discussion, thinking about reasonable adjustments, you know, it demonstrates that you're acting in accordance with your duty of care. Potentially it highlights to the employee that, you know, there is an issue, and it might encourage them to think about whether there's anything else they can do, you know, to combat it. For example, roping in additional support or childcare, you know. Can grandma, granddad pick up the child from school instead, you know, things like that. And it also gives you an opportunity to discuss what support may be viable. So what have you actually got in your organisation that you could amend or adjust accordingly? Okay. Now, reasonable adjustments is a huge subject area, and this really doesn't do it justice, okay? But it is the most common area where disability discrimination arises, okay? The most common. Again, it's a phrase that people with a mind for HR become aware of, but I'm not sure that employers are really aware of the fact that this is where disability discrimination arises most often. Okay. So, your tick list once again. Let's have a policy again, which explains how absence might be dealt with to manage your employees' expectations. Okay, so look at revisiting that. And again, be consistent in your approach so that everybody is treated the same way. Okay, and this is likely to require you to monitor absence. So think about something you can put in place to do that effectively. Now, your manager should understand that it may not be fair to treat everyone the same way. Okay. Very easy for us to think everybody's got to be treated the same, okay, and that's nice and all, but it's perhaps not realistic. And actually, what is more fair is to recognise that some people may be at a disadvantage, and so we need to do what we can to support them, to elevate them to be on the same level as everybody else, okay, and that is particularly required as a result of the Equality Act for people who have a protected characteristic, which is having a detriment on them trying to observe your provisions, criteria and practices. So further to that comes the obligation, again derived from the Equality Act, to make reasonable adjustments. I would strongly advise that you always have a documented meeting, okay, documented so there is evidence to move forwards from in the future, with the employee to check what their situation is. You know, do they have a serious reason for the absences, which means that the situation should not be handled as misconduct. We're not going down the disciplinary route here. We might have to go down a capability route instead. Okay. Without that meeting, you're potentially just duplicating very difficult, hard work for yourself. So moving on then now to look at giving you some legal tips on longer term absence management. Okay, so this is going to be a quick look because again, it's another huge subject area and we don't have time to go through it all. So let's look at giving you some tips that you can take away and bear in mind. I've mentioned this, but capability, or in this case, medical capability, is one of the 5 potentially fair reasons for dismissal, okay, under the Employment Rights Act. And the aim of this process and the procedure is to protect employment. Okay, tribunals will take a dim view on anyone who has gone down this route with a view to dismiss. Okay, the aim is to protect employment and to rule out how you can protect employment. Dismissal must be a last resort. Employers are obligated to ensure that no one suffers from unlawful discrimination on the grounds of a disability. Okay, unlawful discrimination. I just emphasise that because, and I'm saying this tentatively, but sometimes discrimination can be justified, okay? If you think that somebody is saying to you, I'm being discriminated against, but you think you can justify that, please seek advice before you take any further action, okay? Because if it is not, then it can only be unlawful discrimination. That's the only alternative. You know, it's either justifiable or it's not. And there is a tall order that has to be met to make sure that it is justifiable. Adjustments then. These are anything which can reasonably be removed, adapted, or provided to support an employee. Okay. When you're managing someone who's been off sick long term, we've got a lot of recent case law as well, which indicates very clearly, actually, that a recent medical report must have been obtained, okay, by the employer. And that report must suggest that it is unlikely a return to work in the near future is anticipated, you know, without or unless there were adjustments, okay, but you've got to be able to show that any adjustments which are suggested are not reasonable, okay, and then therefore it is not likely that you can expect an employee to return to work in the near future. It's not likely they're going to be able to do that type of work again, and there are no reasonable alternatives to dismissal. Okay, now this report, it could be a report from the employee's GP, but ideally it would be from an occupational health specialist, okay, because if I'm honest, reports from GPs are not often valuable. If anyone's listening who's had to get them before, you will know that they tend to parrot back what the employee has probably told them. Maybe that's fair enough, and they're only really supposed to comment on the condition, you know, the symptoms, how it's manifesting itself for the employee, and what we need to know is how that impacts on their capability. And a GP is not actually really supposed to do that. That is what an occupational health specialist is for. So get an occupational health report wherever you can possibly afford it instead of a GP report, is my advice to you. And in pursuit of that, please bear in mind the Access to Medical Reports Act, okay? If anyone's on the ball with their GDPR, you may have even watched a webinar where I discussed this. But this act supersedes consent, okay, under the GDPR, which otherwise suggests employers can't get consent from the employee. This trumps that, okay? We have got to follow this act to get consent from an employee before we are allowed access to their medical records. And in pursuit of that consent, we must have given them a summary of their rights under that legislation. Okay, so template letters are a must so that you know you can wheel that out without thinking about it, and have properly obtained consent in the correct way. And you know, if you need us, this is something we can provide to you. So your tick list for long-term absence, tips on reducing risk. Maintain regular contact with the employee. So many times employers still feel that they can't contact their employee while they're off sick. Why not? You're not harassing an employee by ringing them and saying, how are you? You know, how's things going? Do you want to know what's going on at work? That's not harassment. You're not preventing that employee from getting better. I've only seen once actually an employer who I had to tell to calm down with the contact. You know, don't be ringing them every day, of course not, but agree an amount of contact so that they don't feel like you've forgotten about them. You know, and how can you keep, you know, tabs on how they're progressing and whether or not they're likely to return to work if you don't know what's going on with them? You know, so please maintain regular contact with your employee. Don't assume, this happens often, don't assume that a drop in performance is misconduct straight away. Okay? Always investigate first. I can't stress how important I believe investigations are. Some people brush over them and think that they're, you know, a means to the more serious formal hearing. I couldn't disagree more with that. And I'm doing a webinar on that in a couple of months' time, actually. But if someone's performance is deteriorated, that suggests to me that they were once able to do the job, okay? Which means something has happened that means they're now not able to. And yeah, of course, it could just be that they're lazy and don't care anymore, but it could mean that they've got something going on privately that they're not telling you about. So find out before you take disciplinary action against them. I've talked about transparency. When you are having conversations with an employee, invite them to suggest, you know, what of these reasonable adjustments potentially they think are going to be appropriate for them. Okay, you might launch in there having, you know, with all the goodwill in the world, you know, prepped all these possible adjustments that you want to suggest for them, you know, having done your research about, you know, what's appropriate and so on and so forth. They might not need it, they might not want most of it, you know, or they might even suggest something to you much more simple or that you haven't even thought of before, you know. So invite their viewpoint on this, because it does actually encourage them to be more actively involved in trying to maintain their own capability. You know, my employer's helping me, I'm going to try and help my employer where I can, you know. It just incites commitment to support you as their employer, engages them, and it, again, on your part, just demonstrates your reasonableness to listen. Please, please, please be in receipt of an up-to-date report, okay, before even considering dismissal on the grounds of medical capability. It must be up to date, which does usually mean within the last month or so, okay? Employers who have gotten umpteen reports, but the most recent one was a couple or 3 months ago, have failed in tribunal, okay? So be in receipt of a recent report, and crucially then ensure that you've got it documented, because you might not remember once you get your summons through, that all possible reasonable attempts to make adjustments have been tried or have been ruled out for justifiable reasons, okay? Extremely important to show that we have exhausted these routes. So if you're still with me, just the last little section then now, we're nearly there, go and get lunch after this. So when you can dismiss due to absence, and again, I've just done this as a summary, okay? We can dismiss for absence when an employee is AWOL and they failed to attend a disciplinary hearing in which they were forewarned that if they didn't come along, we would hear it in their absence. And they should really have been forewarned as well that this may result in dismissal. We may also dismiss when an employee has persistent short-term absence. Okay, now I've spoken about initial approaches that you might take to try and deter that in this webinar, but going forwards, you know, if we have established that this is not a medical capability route, it means we have to deal with it as misconduct, even if you believe the reasons why they were off, okay, cold after cold after cold, and no underlying condition, okay. You would follow your disciplinary procedure. You might end up on a first written warning, okay. You set targets. they don't meet those targets, you follow the disciplinary procedure again. They still have a live first written warning, you move to a final written warning, and so on until the last available option is dismissal. Okay, so a dismissal of this nature is most likely to be a dismissal following warnings, okay, and it would most likely be a dismissal with notice. You may also dismiss an employee once you have exhausted a medical capability process and ruled out any possible alternatives to dismissal. Okay. But we might also see employees leave us if they have resigned. You're trying the assume resignation route. And you can look at exiting via a settlement agreement as well. Okay, this is not a dismissal, this is a mutual parting of ways, but other avenues that might come up. So that is us. I've mentioned a few times actually that a key way in which you can minimise risks is by ensuring you've got proper policies in place and that your managers understand and are following them, and that your employees perhaps understand them as well, you know, so that they can't argue that they weren't aware of what to expect. E-learning is a great way of raising this awareness, and is something we're launching at the moment. So in addition to reading, reviewing and accepting policies and documenting that, we've got a suite of e-learning modules that are available. And these are built around providing further information to support understanding of those policies and practical application as well. So at the moment, we've got compliance modules relating to the following pieces of legislation, which is important for your managers to be aware of. And we also have modules that will help employees' personal development, so things like people skills, performance management, managing teams, and so on. Okay. So get in touch with us if you're interested in this, because, you know, it's a quick package that you can have access to, which helps to minimise your risks and provides you immediately with evidence that you have acted in your duty of care and discharged that. And I've said, you know, this is a massive topic and we've skimmed through a lot today, but I do hope it was helpful, you know, some helpful tips to take away. But why not come along to our seminar? It's going to be a day-long one, in a couple of locations, find one that's near to you, and join me and my other colleagues who will be doing an interactive workshop. It should be fun. If you do have any questions about anything I've discussed, let me know. Please do get in touch and connect with us. We're getting social, so join us. Thank you very much. I hope you've enjoyed this. I hope it was informative, and I hope you'll join us again another time. Thank you. Bye.